say which, and I would give my former student, John Roberts, a B-. His opinion doesn't rely on any intelligent dissection of the separation of powers. He makes it up as he goes along. He has nothing, absolutely nothing, to say about the important hypotheticals that the justices in dissent pointed out, and they weren't just hypothetical. They came up in the oral argument. The immunity that the majority granted was even greater than that which the president's lawyer, John Sawyer, asked for. To begin with, the delay itself gives the president de facto absolute immunity. More than that, the dissenters, especially Justice Jackson, pointed out that the court has it upside down, almost like the upside down flag that Alito flew, has it upside down when it says that if the president uses his official powers to commit crimes, all crimes apparently, including murder, then he gets either absolute immunity if the power is at the absolute core, or presumptive immunity, which is a vague notion, if the immunity is for an official act. But as the justice pointed out, Justice Jackson, it's all the worse if the president uses powers available only to him to commit crimes. The court never explains why it has turned things upside down that way. There is no precedent supporting what the court did. There has never before been any immunity from criminal prosecution suggested in any court decision, state or federal, in the history of the United States of America. This is a sad day, not just because of the license it gives to Donald Trump, should he ever become president again, to get rid of this case altogether and commit all manner of crimes without ever being held accountable, but because of what it does to the future of the country. Let's assume that we've somehow gotten past the MAGA plague and that we don't have a Trumpified government. There will be future presidents who will take it as very tempting to become president, knowing that it's a get out of jail free card for everything except purely private behavior. And even there, when many of us believed, and as a former professor of evidence as well as constitutional law, when I was confident that you could at least use evidence of official acts, even though you might not be able to prosecute for them, you could use that evidence to show a pattern and to show the motive of the wrongdoer. Here the court says you can't look at motive. It doesn't matter if the former president is trying to benefit himself rather than the country. And that is only Justice Barrett disagreed with the men on the court when she said that at least the evidence should be used.
Exactly.
So this is a disastrous decision.
Evidence certainly coming up a lot. I'd love to get your take as well. Justice Clarence Thomas raised some questions about whether the Attorney General, Merrick Garland, had actually violated the Constitution when he appointed Jack Smith as special counsel. I know you've heard this argument before. It's one that Donald Trump's team has made. What do you think of that coming in Justice Thomas's opinion?
I think it's ridiculous, honestly. Every other judge has rejected it. No other justice found it even worth commenting on. The lawyers for Donald Trump didn't press it in the argument below. It makes no sense. The laws make it clear that the Attorney General has the power to promulgate regulations in accordance with the Administrative Procedure Act, delegating partial authority over particular matters to subordinates. The special counsel is a subordinate. He's not supervised day to day, but the regulations specify that any major decision he makes needs the approval of the Attorney General. So Justice Thomas just got it completely wrong in that bizarre separate concurrence.
Laurence Tribe, always good to have you with us. I have a feeling, as you noted, you were in your grading. I have a feeling this will come up quite often for you as you move into the fall. Thank you again for being with us tonight. Out front next here.